Good day everyone. We are the Group 5 and now please allow me to introduce my group members. Greggy Maceda, Rigo Nan Caintoy, Rheill Salceda, and I am Erven Ellevera. There are only 4 of us in this group. You can also call us F4. We are going to report about the article from 1828 to 1840. Chapter 3. Dissolution and Winding Up. Article 1828. The dissolution of a partnership is the change in the relation of the partners caused by any partner ceasing to be associated in the carrying on as distinguished from the winding up of the business. A dissolution occurs whenever there is a change in that relationship between the partners or among the partners. Isa sa mga rason para ma-dissolve ang partnership kapag nag-withdraw ang usa ka partner, obviously, there will be a change in the partner's relationship and it will cause the dissolution of the partnership. But it may lead to continuation of the business or winding up. Dissolution does not always lead to liquidation or winding up, but dissolution may also lead to or may proceed to continuation or carrying on of the business. Next, Article 29. On dissolution, the partnership is not terminated but continues until the winding up of partnership affairs is completed. So, mao ni akong giingon ganina, pag nagka-dissolution, the partnership is not terminated but pwede gihapon siya mag-continue until the winding up of a partnership affairs is completed. Next is Article 1830. Dissolution is caused, number 1, without violation of the agreement between the partners. Which means, bisan pag wala kay gilabag na violation, pwede gyapon ma-dissolve ang usa ka partnership. First, by the termination of the definite term or particular undertaking specified in agreement. For example, the contract was already done or accomplished. There's no more reason for the partnership to continue existing because the reason why the partnership was formed is already done, which is tapos na ang kontrata. Next, by the express will of any partner who must act in good faith when no definite term or particular undertaking is specified. For example, ang usa ka partner is nag-withdraw na. The partnership will dissolve as long as it is made in good faith and also no definite term agreement or particular undertaking is specified. Letter C. By the express will of all the partners who have not assigned their interest or suffered them to be charged for their separate debts either before or after the termination of any specified term or particular undertaking. All the partners di can agree na ma-dissolve ang usa ka partnership but take note na ay condition, dapat walay ma-appeal na third person. Next, by the expulsion of any partner from the business bona fide in accordance with such a power conferred by the agreement between the partners. Which means, pwede ka makapatalsik og usa ka partner even without violation of the partnership agreement. Next is number 2. In contravention of the agreement between the partners where the circumstances do not permit a dissolution under any other provision of this article by the express will of any partner at any time. Next, by any event which makes it unlawful for the business of the partnership to be carried on or for the members to carry it on in partnership. For example, kamong magbarkada nag-form og partnership agreement na magbaligya og vape sa CDO. Then suddenly ang City Council naghimog batas nagipagbawal na ang pagbaligya og vape sa CDO. Which means automatic dissolve ang inyong partnership kay inyong business na himong unlawful na. Next, number 4. lost of a specific thing. Lost before delivery, dissolve ang partnership. Lost after delivery, not dissolved but partnership assumes the loss. Loss where only use or enjoyment contributed. Partnership assume loss, partnership dissolved. 5. Death of any partner. Automatic dissolution. Business affairs will only continue insofar as to it winding up. However, partnership agreement may provide the partner that withdrawal or admissions of new partner will not affect a dissolution. 6. By the insolvency of any partner or of the partnership. When we say insolvency, di na sapat ang assets to pay for his liabilities or obligation. Number 7. By the civil interdiction of any partner. And lastly, number 8. By decree of court under the following article. That's all. Thank you.
Good day, everyone. I am Ralph, Greggy, and Maceda, and I'm going to discuss the Article 1831, Article 1832, and Article 1833. Article 1831, on application by or for a partner, the court shall decree a dissolution whenever 1. A partner has been declared insane in any judicial proceeding or is shown to be of unsound mind. A partner becomes in any other way incapable of performing his part of the partnership contract. 3. A partner has been guilty of such conduct as tends to affect prejudicial the carrying on of the business. 4. A partner willfully or persistently commits a breach of the partnership agreement or otherwise conducts himself in matters relating to the partnership business that it is not reasonably practicable to carry on the business in partnership with him. The business of the partnership can only be carried on at a loss. 6. Other circumstances render a dissolution equitable. So, ibig sabihin nito is there must be a proactive filing. Dapat may filing muna for dissolution bago ma-dissolve ng korte. Those enumerated instances kagaya ng 1A partner has been declared insane in any judicial proceeding or is shown to be of unsound mind and to be followed. Yun ang mga instances na kung saan ang korte maglalabas ng isang court order to dissolve the partnership. Kapag may nakita ang korte na kahit sa lang sa mga enumerated instances magbabaya ng desisyon to dissolve the partnership. Grounds of dissolution by decree of court. Ito yung pinaliit lang yung mga enumerated instances. So, insanity, makikita nyo yung number 1 sa enumerated instances. At ito'y nagsasabi na a partner has been declared insane. Insanity. An insane person cannot give a partner in the first place. Diba? Yung number 2, a partner becomes in any other way of incapable of performing his part of the partnership contract, meaning he cannot act for itself na example. Dito yung na-comma yung misconduct and persistent breach of partnership agreement. Ito naman yung kapag yung ibang partner gusto niyang paalisin because of this misconduct, pero ito yung partner nyo is ayaw pang umalis bilang isang partner, then wala tulong yung partnership agreement nyo. To expel the partner, then you can go to the court and have partnership. dissolved because of the misconduct. Example dito is yung palaging lasing at nangungupit siya sa cash register ng business nyo. D. Business can be carried only at loss. Yun yung wala na silang choice, like ngayon, pandemya, kung i-continue nilang partnership business nila, they will just incur loss. With that, it is a valid ground of dissolution by the court. Art 1832, except so far as may be necessary to win a partnership affairs or to complete transaction began, but not then finish the solution terminates all authority of partner to act for the partnership. And Article 1833, where the dissolution is caused by the act, death, or insolvency of a partner, each partner is liable to his co-partners for his share of any liability created by any partner acting for the partnership, as if the partnership had not been dissolved, unless ayon sa Article 1832, kapag ang paglusaw ay hindi sagawa kawalan ng pakiramdam o sa walang bahala ng iyong kapartner sa business, ito ay kinakailangan ng Article 1833. Ang bawat kasosyo ay mananagot at kanyang katuwang para sa kanyang bahagi ng anumang pananagutan na nilikha ng kung sino mang kumikilos para sa pakikipagtulungan, kung kaya't ito'y hindi na malusaw ng dahil sa pagliban sa kasosyo. Case example, Mr. Marvin and Miss Densha are partners in a business called Gulays. Gulayan, each partner is responsible to his or her partner for his or her share of any responsibility to create anyone who helps in their business partnership. Thank you.
Article 1834. After dissolution, a partner can bind the partnership except as provided in the third paragraph of this article, by any act appropriate for winding up partnership affairs or completing transactions unfinished at dissolution. Example ani is yung partnership ni A and B ay dissolved. Tapos si B bininta niya non-cash assets ng partnership. Therefore, yung acts ni B is binding sa partnership. Acts for completing transactions unfinished at dissolution. Example ani is partnership ni A and B ay dissolved. Tapos, dineliver ni B yung mga undelivered goods ni X para makomplete yung unfinished transactions. Yung act ni B is binding sa partnership. Had extended credit to take the partnership prior to dissolution and had no knowledge or notice sa dissolution. Example ani is partnership ni A and B ay dissolved. Pero bago yung dissolution ng partnership, si B entered a transaction with X. Yung partnership is liable to the contract of sale, though he had not so extended credit, had nevertheless known of the partnership prior to dissolution, and having no knowledge or notice of dissolution. The fact of dissolution had not been advertised in a newspaper or general circulation in the place, or in each place if more than one, at which the partnership business was regularly carried on. Example, partnership ni A and B ay dissolved. Pero bago yung dissolution ng partnership, si B entered a transaction with X, yung partnership is liable to the contract of sale. Pero if the dissolution is na-advertise sa newspaper, then the partnership is not liable. Where the partnership was dissolved because it was unlawful to carry on the business unless the act is appropriate for winding up the partnership's affairs. Example, yung partnership ni A and B ay na-dissolve kasi yung binibenta nila was declared unlawful. Pero originally, di naman talaga unlawful. Tapos si B nagbenta kay X. Then the partnership is not liable. Where the partner has become insolvent. Example ani is yung partnership ni A and B is dissolved kasi si B is insolvent. Tapos B entered a contract with X. Therefore, the partnership is not liable. Where the partner has no authority to wind up partnership affairs except by a transaction with a third person who is in good faith. Example, yung partnership ni A and B was dissolved. Din si B lang yung liquidating partner. As a general rule, any transaction entered by A and B after ng dissolution is not binding. So the partnership is not liable. Article 1835. The dissolution of partnership does not itself discharge the existing liability of any partner. In order na ma-discharge lang liability ng any partner, kailangan mag-agree ng mga sumusunod: the partner, the other partner, and the creditors. The individual property of a deceased partner shall be liable for all obligations of partnership incurred while he was a partner, but subject to the prior payment of his separate debts. Example is when yung partnership ni A and B was dissolved dahil sa death ni B. Tapos si X is a partnership creditor while Y is a private creditor ni C. Is the separate property of C liable to X? The answer is yes. However, unang mababayaran muna yung liability ni C kay Y. Yung natirang property ni C ay para sa partnership creditor with X. Article 1836. Unless otherwise agreed, the partners who have not wrongfully dissolved the partnership or the legal representative of the last surviving partner, not insolvent, has the right to wind up the partnership affairs, provided, however, that any partner, his legal representative, or his assignee, upon cause shown, may obtain winding up by the court. Kinds of winding up or liquidation. Extrajudicial liquidation. Liquidation done by the intervention of the court. Who will wind up? Liquidating partners as agreed upon by all the partnership. The partners who have wrongfully dissolved the partnership. Last, the legal representative of the last surviving partner who is not insolvent. Juridical liquidation. Liquidation done by the intervention of the court. Who will wind up? The person appointed by the court. Mora to. Thank you.
Good day everyone, my name is Jhon Salceda and I am one of to report the Article 1837 to 1840. Article 1837. When dissolution is caused in any way except in contravention of the partnership agreement, each partner as against his co-partners and all persons claiming through them in respect of their interest in the partnership, unless otherwise agreed, may have the partnership property applied to discharge its liabilities, and the surplus applied to pay in cash the net amount owing to the respective partners. But if dissolution is caused by expulsion of a partner bona fide under the partnership agreement, and if he expelled partner is discharged from all partnership liabilities either by payment or agreement under the second paragraph of Article 1835, he shall receive in cash only the net amount due him from the partnership. So it says na kung mawala ang bisa ang pag-partner except kung naay contribution daw kuno o paglabag sa agreement nilang duwa ka mag-partner, pwede sab sila maningil sa gibayaran nga nagasto gikan sa properties, cash o surplus sa businesses. Article 1838, where a partnership contract is rescinded on the ground of the fraud or misrepresentation of one of the parties thereto, the party entitled to rescind is without prejudice to any other right entitled. It says nga kung asa sa mga isa ka kontrata sa pagkipagsosyo kay natanggal tungod sa pagkailad o sayop nga pamaagi sa usa ka partido niini. Article 1839. In setting accounts between the partners after dissolution, the following rules shall be observed subject to any agreement to the contrary. It says daw kuno nga ang mga sumusunod na panuntunan kay dapat sundan jud para sa pagkaayos sa tanan nga account, then para jud magkaayos sa mga naguba nga mga trust issues. So the following rules must be followed or settling accounts between partners after dissolution subject to any agreement to the contrary. So this is the number 1. The assets of the partnership are A, the partnership property; B, the contributions of the partners necessary for the payment of all the liabilities specified in number 2. So number 2, the liabilities of the partnership shall rank in order of payment as follows: A, those owing to creditors other than partners; B, those owing the partners other than for capital and profits; those owing to partners in respect of capital; D, those owing to partners in respect of profits. So number 3, the assets shall be applied in the order of their declaration in number 1 of this article to the satisfaction of the liabilities. 4, the partners shall contribute as provided by Article 1797 the amount necessary to satisfy the liabilities. 5, and assign for the benefit of creditors or any person appointed by the court shall have the right to enforce the contribution specified in the preceding number. So number 6 daw, any partner of his legal representative shall have the right to enforce the contribution specified in number 4 to the extent of the amount which he has paid in the excess of his share of the liability. The individual so the individual property of a deceased partner shall be liable for the contribution specified in number 4. So number 8, when partnership property and the individual properties of the partners are in possession of a court for distribution, partnership creditors shall have priority on partnership property and separate creditors on individual property, saving the rights of line of secured creditors. So number 9, where a partner has become insolvent of his estate in insolvent, the claim against his separate property shall rank in the following order. So nanapod ning mga order. So A, the owing to separate creditors; B, the owing to partnership creditors; C, the owing to partners by the way of contribution. As what I said, ang Article 1839 nga sundon ang panuntunan nga dapat sundan jud para sa pagkaayos sa tanan account o maabalik ang mga naguba nga mga trust issue gid. So that's all the Article 1839. Article 1840. So in the following cases, creditors of the dissolved partnership are also creditors of the person or partnership continuing the business. So 1. When any new partner is admitted into an existing partnership, or when any partner retires and assigns his rights in the partnership property to two or more of the partners, or to one or more of the partners and one more third persons. If the business is continued without liquidation of the partnership affairs. So ang gingon daw kuno nga kung ang isa ka bag-o daw nga kasosyo kay nakasulod nga naa na daw siya ilaing kasosyo, or ang isa kasosyo kay nag-retire or nagtatalaga. So number 2, when all but one partner retire and assign assign the rights in partnership property to the remaining partner who continues the business without liquidation of partnership affairs, either alone or with others. Kung ang bawat isa maliban sa isa kasosyo nga nag-retire o nagtalaga sa usa ka namatay nga kasosyo, kay aduna siya ay karapatan nga ang kuno niya ang nabilin nga kasosyo o mga negosyo. Moto siya. So number 3, when any partner retires or dies and the business of the dissolved partnership is continued as set forth in number 1 and 2 of this article with the consent of the retired partners or the representative of the deceased partner, but without any assignment of his right in partnership property. Kung ang isa kakasosyo nga nag-retire lagi daw o namatay niyang, pwede siya magapadayon Japon sa negosyo sama sa giingon sa artikulo sa 1 ug 2 o gi-aprobahan sa mga retired na kasosyo o ahente sa mga namatay nga kasosyo, pero walay kuan nga pagtatalaga ng paghabol sa pakikipagsosyo sa tagiya. So mo siya. So number 4, when all the partners or their representatives assign their rights in partnership property to one or more third persons who promises to pay the debts and who continue the business of the dissolved partnership. Kapag ang lahat ng mga kasosyo, mga kasosyo do kuno o kanilang ahente kay nagtalaga ng kanilang mga karapatan sa pagmamayari ng sa mga tag-iya o sa higit pang mga ikatulong partido na naggabuhat sa bayaran sa mga obligasyon o pwede ipadayon ang aktibidad nga pakikipag tinabanga matapos na nga mahuman kini nga natunaw daw. So number 5, when any partner wrongfully causes a dissolution and the remaining partners continue the business under the provisions of Article 1837, second paragraph number 2, either alone or with others and without liquidation of the partnership affairs. As what I said in Article 1837, number 2 nga kung ang mga kasosyo nga wala na dahilan sa paglusaw sa maling nais do kuno naay karapatang ipadayon na negosyo sa pareho gyapon nga pangalan. So sikinsa man sa ila kay pwede silang makabuhat pamaagi sa ilang kasabutan. So number 6, when a partner is expelled and the remaining partners continue the business either alone or with others without liquidation of the partnership affairs. Kapag daw ang usa ka kasosyo nagipalayas o ang mga nabilin nga kasosyo kay pwede magpadayon sa negosyo nga pamaagi gyapon sa ilang kagulingong kasabutan. And that's all also the Article 1837 and 1840. So thank you.